They got him? Oh, all right, good. All right, let's bring him out. James Stevens on page 21.
Good morning again, Your Honor. For the record, Zachary Schaefer here on behalf of Mr. Stevens. We do have a negotiated disposition for the court's consideration this morning.
Yes, sir.
Your Honor, Mr. Stevens has authorized me to withdraw previously enter pleas of not guilty, enter plea of guilty to counts 1, 2, and 3 of the information, Your Honor, with the understanding he would be sentenced concurrently all 3 counts, Your Honor, to 12 months Duval County Jail, credit for 49 days time served, and court costs would be imposed.
And Mr. Stevens is not entitled to a PSI?
That is correct, Your Honor.
Is this the state's recommendation in this case?
It is, Your Honor.
It's within the guidelines?
It is.
And we had previously discussed the case. I don't recall what was necessarily on the record, but Mr. Schaefer, the court is willing to place Mr. Stevens. The court will accept the negotiated sentence here today, but the court is also willing to place Mr. Stevens on probation at the conclusion of his jail sentence to undergo drug treatment, and you are declining that opportunity.
That is correct, Your Honor. That would not be feasible based on Mr. Stevens' living situation, Your Honor.
Okay. And the court would intend to do time served on counts 2 and 3, state.
That's fine.
Mr. Stevens, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Your name is James Stevens. You've heard what your attorney has said, that you wish to plead guilty to the 2nd-degree felony of sale or delivery of cocaine. You could have received up to 15 years in prison on that charge, and 2 third-degree felonies of possession of cocaine and possession of controlled substance. You could have received up to 5 years in prison on each of those. Is that what you wish to do, is plead guilty to those 3 charges?
Yes, sir.
Have you had enough time to speak to your attorney about what you're doing today?
Yes, sir.
You satisfied with his advice and representation? You under the influence of anything this morning? Anybody threaten you to get you to plead guilty? You're pleading guilty because you are guilty of the charges.
Yes, sir.
You understand you can plead not guilty and have a jury trial. You're giving up that right.
Yes, sir.
Already stipulate to a factual basis.
State stipulates.
Defense stipulates, Your Honor, there's no known DNA evidence that would exonerate Mr. Stevens.
Court finds a factual basis exists for the entry of the plea. State you agree, no exonerating DNA evidence.
State agrees.
Mr. Stevens, you understand if you were not a citizen of the United States, the entry of the plea could subject you to deportation. And you understand if these were sexually motivated offenses, or if you've been convicted of one before, that the entry of the plea could subject you to a civil commitment at the end of your sentence. And Mr. Stevens, Mr. Schaefer went over with you this 2-page blue form I'm holding up called plea of guilty and negotiated sentence. Did he read it to you front and back? Did you understand everything on the form?
Yes, sir.
Any questions about anything that's on the form or anything that's happening here today? Court finds that Mr. Stevens' plea is freely, knowingly, and voluntarily entered with a full understanding of the nature and consequences of the plea. Therefore, the court accepts your plea of guilty in count 1 to the 2nd-degree felony of sale or delivery of cocaine, adjudicates you guilty of that offense, and issued a 1 year in the Duval County Jail with credit for 49 days time served. In counts 2 and 3, adjudicates you guilty of the 3rd-degree felonies of possession of cocaine and possession of controlled substance. Adjudicates you guilty, 49 days Duval County Jail, 49 days credit. All 3 sentences will run concurrently with each other. You'll pay $618 in court costs. And state have an announcement on counts 4 and 5, the misdemeanors? Or is he pleading to those as well? Because you just said counts 1, 2, and 3. You wanted to plead to the misdemeanors? Maybe I shouldn't have assumed.
All right, he can plead no contest to this.
Well, he can plead guilty because he believes it's in his best interest. You're so mean.
He'll plead guilty because it's.
All right, Mr. Stevens, the state doesn't want to drop those misdemeanor charges. You gonna plead guilty to those?
Yes.
All right, it's possession of less than 20 grams of marijuana and resisting without violence. You could have gotten up to a year in jail. I'm going to adjudicate you and give you time served. You want to do that?
Yes.
All right, so that's what we're doing. And everything runs concurrently.
Thank you, Judge.
Anything else from the state? Defense?
No, sir.
Mr. Stevens, you have 30 days to appeal this sentence if you believe it to be unlawful. If you cannot afford an attorney, one will be appointed for you. Thank you, sir. That'll conclude your hearing in this case. Thank you, Mr. Schaefer. You didn't tell me that up front. You heard him, same as I heard him. I heard him say counts 1, 2, and 3. That's when you jump in and go, what about 4 and 5?
If we could call case 45 on the court's calendar, Donta Williams, page 23.
Mr. Rosati, good morning.
Maybe we approach.
No, we got to get through this. What's going on? What do you want to do? Are you close to a resolution?
Not yet.
So what do you want to do? Got to set the case for trial then. Been telling you that since February. You're making me look bad. Carlisle's going back there and sitting there going, he doesn't give me that long a
I
time.
never heard him say that. Judge, the state I filed a motion. It's a CI case and the state has to talk to the detective. And
You want to come back next week? I might have a little more time.
is that good? I defer to the state.
Your Honor, I will make my best efforts to speak with the detective. I know he had the date.
All right, we're going to talk about it next week, July 13th, if you're available.
Yes, sir.
All right, July 13th, and then remind me that I wouldn't let you approach today. All right, see you then.
Thank you, sir.
Mr. Carlisle, what you got? Oh, you're just observing? Oh, okay. Okay, what's left besides our hearing? 4 more still? Holy smokes.
Corey Posey on behalf of the state, if we can next call O'Brien Jackson, number 1718, page 1.
O'Brien Jackson on page 9.
Should be in the
Mr. Bennett. Calendar shows he's out of custody. O'Brien Jackson,
Elizabeth Ishmael on his behalf.
have you had any contact with him?
No,
And was this a diversion reject or not?
No, Your Honor, this is a new case.
All right, Madam Clerk, any reason for the court not to issue a capias? All right, court issues a capias for Mr. Jackson with no bond and a forfeiture date. Well, on the one case, he had a bond, and on the other case, he was ROR'd. So on the case with a bond, we'll have a forfeiture date, well, capias on both cases, forfeiture date of July 20th. Are these bonds correct? 3727, burglary to an occupied dwelling and written threat to kill. Bond was $1,503. And then the other charge is written threats to kill. And he was ROR. Is that right? Madam Clerk, do you show what happened there? Were those bonds set in J1? They were set in J1? Is that right? And for the record, I didn't ask who it was. I just asked them that it was set in J1. Is that right? Do we have a bond recommendation from the state in there? Just out of curiosity.
Yes, Your Honor, as for the count of burglary to an occupied dwelling, state request 25,003.
And I'm not asking now because I just issued a capias with no bond. I meant back in J1.
Oh, Your Honor, it was requested at J1. I apologize.
Okay,
Yep.
all right.
By the state.
Well, in any event, capias with no bond. And here we are. Okay, what's left? Ms. Patterson, you got something? Ooh, we're drawing quite a crowd here this morning.
If we could call case 30 on the court's calendar, Kenneth McKellen, page 15. I believe he's in the chute.
Short on behalf of Mr. McCown, who's present, and approaching to my right. Your Honor, I'm just asking for a pass date to the end of next week, Thursday if possible, so I can review Mr. McCollum's body worn cameras with him.
July 14th for pretrial.
Thank you.
Thank you. We'll see you next week.
Your Honor, next call number 33, Patrick Middleton, page 17.
Elizabeth, this short on behalf of Mr. Middleton, who's present at custody, approaching to my right, Your Honor.
Okay, here for arraignment and initial plea conference.
Actually, Your Honor, I think his arraignment was continued. What's set today is a motion to modify his
All right,
bond.
State hadn't filed the charges yet.
No, Your Honor.
And what's the motion? I see the motion to modify, but he's out of custody. What are you wanting to do here?
In essence, Your Honor, we're asking to allow him to travel.
His brother's getting married in Destin and he wants to go.
Yes, Your Honor.
All right, any objection?
No, sir.
All right, the motion to modify is granted. You got a proposed order?
I can submit one to the court.
Send one to Ms. Gardner and I will sign it. All right. So, Mr. Middleton, obviously behave yourself while you're out on bond. And state hadn't filed the charges yet. It's up to them as to whether they do and when they do. But you need to stay in contact with your bonds person, with the clerk's office and with your attorney to make sure you show up for your court dates.
Yes, sir, I will be here.
All right, very good.
Thank you.
Yes, sir. One more, and then we have our hearing. What's left? Who is it? Daphne Limbaugh Wilcox on page 14. That's calendar says second degree murder here for appearance of counsel. Anybody know anything about that?
It's currently assigned in the words in our system, I can reach out to her.
Added on for determination of court-appointed counsel. Oh, I see. Apparently, Judge Flower found the defendant solvent in J1, but the defendant, Ms. Isherwood, may be eligible for the services of the Office of the Public Defender. But why don't we pass the case to, has the state filed the charges? No? And do we have Ms. Limbaugh Wilcox? All right, let's just pass it till tomorrow. Y'all figure out what's going on there. July the 7th or whatever it is. Okay, court's is that it besides our hearing? Okay, we're gonna be in recess for 5 minutes and we'll have our hearing. Recess. Yes.
Thank you.
John, good past date? That's the 11 o'clock.
That's what I thought.
I was confused. So, we've got investment. Schedule. Jones is out. Oh, perfect. I got the feed over. Judge Sal can't go on vacation. This is the, you know what time I went home yesterday? 11:30.
No way.
Misdemeanor trial. We'll go. Yeah. All right. Judge Sadler. It was. Okay.
There's a pick and go until 11:30.
Court attention.
Why not?
I didn't.
You guys ready? Yeah, let's call Charles Jones on page 12. And Mr. Fusco's here. And Ms. Owens. And good morning. I appreciate y'all's patience. I know we're running a little bit late. You waiving Mr. Jones's appearance today?
Yes, Your Honor.
Okay. And I know we're here, I think, on dueling motions. Is that right?
Yes.
Yes, Your Honor, there are several motions filed, but I think the main one that will have an effect on all the other motions is the state's motion to strike the discovery disclosure, specifically Ms. Owens as a defense witness category A.
Okay. I've read them. Other than the lack of case law supplied by either side, I'm interested to hear what y'all have to say. Doesn't matter to me who goes.
Yes, Your Honor, it's the state's motion, so I figured they would go first on how they want to proceed.
All right, Ms. Owens, you good with that?
I am, Your Honor.
All right.
Your Honor, we did file a motion to strike paragraph 3 in the defendant's disclosure of prosecution. In that disclosure, the defense listed a number of the witnesses that the state had already disclosed, but it's also myself. Your Honor, I'll say that there is no fundamental rule or judicial system that I am aware of worldwide where a prosecutor handling a case is subject to being called as a witness. I don't know if Your Honor knows of.
I'm not familiar with the judicial systems in far-flung lands, but okay.
Certainly in this country, again, I have, and I think it's clear, I mean, it's most important at the outset to make it clear that I was not actually there when the actual traffic stop occurred. So Mr. Jones is charged with fleeing. In this case, he was stopped by a gang unit in undercover vehicles after having been observed commit some traffic infraction. He failed to stop, and when he eventually did, they made at the scene. I gave them advice about what to seize and not to seize. We discussed what to charge. Well, we had discussions about the case in general. I would eventually be escorted back to the CJIC office, which is part of the state attorney's office. The CJIC office has interview rooms in it, and CJIC stands for Crime Gun Intelligence Center. They have 2 separate interview rooms that are have cameras in them that feed to a conference room. The CJIC office itself is also, again, in the state attorney's office, but so are the gang unit offices. So this is a very common place for them to take individuals whom they have some type of interest in to interview. I would then go to inside of the conference room and watch Mr. Jones's interview. Shortly thereafter, go home. So that encompasses my involvement in this case. And I'll state one more time for the record that I was not present during the actual traffic stop.
So what do you want me to do here?
But I, just as my motion would suggest and request of Your Honor, I ask that you strike my name from the defense's disclosure. And
Okay, I'm listening.
I could go on, Your Honor. I can't imagine what type of precedent this would set if an assistant state attorney was had to be deposed just because they have some kind of like prior knowledge of a defendant. I honestly don't and we had reached out to the defense before and asked them if they had any case law or any reason to believe that I should be deposed that we're unaware of. But standing here today, that type of precedent, the type of precedent it would set, I can't imagine where it would end.
Okay, and I just want to make sure I understand what you're wanting me to do, because your motion asked to strike their entire response, and it lists 13, according to your motion, it lists 13 names, but today you're only asking me to strike yours.
Well, Your Honor, I believe you're looking at the state's motion to strike that I had previously filed based on a prior defense disclosure. But that defense disclosure had been withdrawn, so I filed a new motion to strike.
Oh.
And in that new state's motion to strike, the title is State's Motion to Strike Paragraph 3 in defendant's disclosure to prosecution. So.
Okay, so all you're concerned about today is your name on the discovery. Got it. All right, Mr. Fusco.
Morning, Your Honor.
Good morning.
Your Honor, unfortunately, I feel that this is essentially a waste of the court's time here. And the proper course of action would essentially be for Ms. Owens' office to recuse themselves from the case, specifically because she was more than just present during this investigation or this traffic stop. As noted in the state's motion, Your Honor, category A witness is an eyewitness, alibi witness, or rebuttal witness present when recorded statements were given, witnesses known to have material information that negates guilt. All of these apply to Ms. Owens. Specifically, Your Honor, she is a material witness who not only participated on scene by observing and instructing the officers, but she essentially dictated what the officers were doing on scene. Just
She said she wasn't at the scene.
I've got a video for the court. I don't think she was.
I did respond to the scene, Your Honor, after the individuals from the vehicle had been detained.
Oh, okay. I got you. All right, go ahead.
So the court is aware, around 4:30 PM, there was a traffic stop. Shortly thereafter, pre-arrest, when 3 of the occupants were seized in a vehicle, Ms. Owens arrived on scene. She was present on scene for at least 2 hours pre-arrest. The officers testified that they did not advise Mr. Jones he was arrested until 8 PM plus at night. So essentially 4.5 hours where Ms. Owens is on scene, instructing these detectives what to do. Essentially, there's conversations on the videos where the officers are advising to take property, personal property of Mr. Jones and the occupants, and to put it into his property to be returned to him. The video then shows Ms. Owens coming up to these officers, advising them that they need to seize all of these phones because they're evidence of a crime. However, nobody has been arrested at this point. She further goes on to instruct them that all of the evidence or all of the property in the vehicle, which noted nothing illegal was found in the vehicle, was all evidence of a crime. And there was no search warrant at this point in time. So after instructing the officers what to seize, what to take possession of, she continues to meet with these officers for hours on scene, discussing how they're going to go about this investigation. Proceeds to follow the patrol vehicles, or they follow her to the state attorney's office, where again, she participates in a recorded interview with Mr. Jones for 2 hours. Your Honor, the very definition of a material witness, she meets all of those requirements. She certainly is material in this case. I'm honestly shocked that we're even having to go through this based on the body worn cameras that clearly show her role in this. In addition, not only is she instructing these officers, within 25 minutes of the traffic stop, she can be seen on video searching the passenger side of the vehicle, the back passenger side of the vehicle, going around to the driver's side of the vehicle, looking inside, then the back passenger driver's side of the vehicle, as well as pointing to cell phones, talking to the officers about whose cell phones is what. And despite one of the 3 occupants being arrested, all of the occupants' cell phones were seized at Ms. Owens' instruction. Clearly, she's relevant to this case. More importantly, Your Honor, during depositions, 7 officers, all of who were present, or however many gang officers that were present, unequivocally testified that none of them made the decision as to what was being taken as evidence. In fact, Officer Ferrari and several others had confirmed that they were instructed to place this in personal property, but it was Ms. Owens who then came up to him and said, no, that is not personal property, it's going into evidence. These decisions of the investigation were made by Ms. Owens on scene, and it's clearly depicted on the body worn cameras. Whether she was present or not for the traffic stop, as the court will see in future hearings, I anticipate, he never failed to stop in the first place, Your Honor. So the fact that she was on scene of a civil traffic stop, which they claim was a felony takedown, for 2.5 hours and investigated this for 4.5 hours before an arrest took place, clearly shows that she's not prosecuting at that point in time. She's a material witness that I do intend to call. I did try to depose her. She was subpoenaed, and the deposition was scheduled to take place last week. There were 3 witnesses scheduled that day. 2, Ms. Owens was present for the first 2, and then when her deposition came around, she walked out of the room saying she would not be deposed. My client certainly is entitled to some of the information that she has.
And that's the basis of your motion to hold her in contempt.
Yes, Your Honor, correct.
Right. That one can be easily resolved. I'm going to circle back to the ones that y'all are bringing before me today. That one's easily resolved because I think, as you know, I would assume you know, Mr. Fusco, the rule of procedure that deals with taking depositions provides that you can take the deposition of the party opponent that's listed as a Category A witness. So if, in this case, the state of Florida lists a witness as a category A witness, you're entitled to depose the witness. If they're not a category A witness, you can only depose them with leave of the court. So there's no basis for an order to show cause under that scenario. So that's easily resolved. But anything else on the motion that we're actually here on today?
Your Honor, I would just further state that the material witness, as it states in case law, is the one who gives testimony going to some fact affecting the merits of the cause and about which no other witness can testify. Clearly, no other witness has knowledge of some of these decisions that Ms. Owens made, and it's only her who possesses this knowledge. Anybody that may have knowledge would be hearsay. So I certainly would like to hear from Ms. Owens as to why these decisions were made before an arrest took place. It's troubling to say the least, Your Honor. I do have, and I don't know if the court even needs to hear or see any of this, but I do have on a zip drive the body worn camera that clearly shows her role for an hour and a half on scene, searching the vehicles and talking to the officers. But I don't know if we have time for that this morning.
Well, a couple things. Just so I understand exactly what y'all are telling me. Mr. Jones is charged, according to the calendar, I don't know that I've seen the information, with one count of fleeing or attempting to elude a law enforcement officer, third-degree felony. That's the only pending charge against Mr. Jones?
Yes, sir.
Is that right?
Yes, sir.
Okay, so that's all the court's dealing with here. So for purposes of this hearing, the court will make a ruling based on that being the charge. So if that's the case, then what does searching the vehicle and all these other things, what's the relevance to this particular charge? Because I'm not getting to the nuts and bolts yet. Because I understand what you're telling me. You're concerned with Ms. Owens allegedly searching the vehicle and whatnot. And that may or may not be relevant to this charge, and it may or may not be relevant to, if he was charged with trafficking and cocaine and she searched and found the cocaine, that's a different animal. So you understand my question?
Yes, sir.
Your Honor, I do think it would help to clarify for the record that just like a homicide scene, every single homicide case I have, I was present at the scene. I did not search anything, did not put gloves on, did not touch any item in that vehicle. I just looked inside of the vehicle and around. So I don't know if we're extending the definition of search to looking inside. of
All I
it.
heard was you searched. That's what I'm going on.
I do want to clarify, and just because I have maybe a moment, I was never in the interview room, so participating in the interview.
I wrote it. I'm glad you brought that up because that was one of my questions about when you said, Mr. Fusco, that she participated in the interview. Did she participate in the actual discussion with your client directly? I know it's a term of art, for lack of a better term, but tell me what you're saying Ms. Owens did.
Yes, sir. So on the actual interrogation video, I did not personally see her in the room. It does show on the body camera where she's outside conversing, where the officers come and go and meet with her, things of that nature. I did not see her personally in that room. The big thing, Your Honor, is had, as Ms. Owens stated, it is common for prosecutors to come to the scene of a crime, a homicide, and investigate a crime that has taken place. This was not yet any criminal offense, in my opinion. The officers clearly stated and told Mr. Jones for 2.5 hours, this is a routine traffic stop. We're going to give you a ride home. They then tell him they're taking him to the state attorney's office to question him about one of his best friend's murders. He's still not under arrest. It's my belief, Your Honor, from watching videos, that had Ms. Owens not arrived on scene, I don't know if these officers would have made an arrest. They clearly did not place him under arrest until that decision seemed to be made by Ms. Owens, at which point they effectuated the arrest.
So what is it? Same question that I asked Ms. Owens. What do you want me to do today?
Your Honor, I think that giving us an opportunity to see what Ms. Owens' role was by at least taking a deposition, whether she's listed as a witness or not, she certainly is going to be involved in the defense, because she is all over the body on cameras, made a lot of decisions in this case. I don't know, this isn't for this hearing today, but at no point did he flee. I mean, rolling 300 feet to a stop. It's kind of ridiculous at this point, Your
All
Honor.
right, I got your concerns. I just need to know what it is that you want me to do. So you want me to authorize you to take Ms. Owens' deposition?
Yes, Your Honor, if need be, list her as a witness to defend Mr. Jones against this charge.
Okay, anything else you're asking me to do today?
Nothing as it relates to this issue, Your Honor, no, sir.
All right, so, and I hearken back to pretty much the first thing I said when we started the hearing, which was that I have read the materials and did not see any case law that was cited. You're a very bright lawyer, and I'm sure you're aware that this is not the first time that courts have been asked to do what you're asking me to do here today. Do you have, so I cannot imagine that this is a case of first impression. I have done no research in preparation for this hearing because that's y'all's job. So what, if any, case law do you have that supports your position and what you're asking me to do here today?
Your Honor, there's been a lot of case law that I've seen for, perjury charges and things of that nature. Nothing specifically related to this, and I would just defer to the rules of discovery. And what it
Are you
has-
telling the, I'm sorry to interrupt you, but are you telling the court that there is no case law in the state of Florida, not in the far-flung lands that Ms. Owens referred to and other judicial systems, but in the state of Florida, that deals with the issue of the defense in a criminal case, wishing to either recuse the state attorney's office, which you mentioned earlier, although you didn't indicate that that's the remedy that you're seeking today, or in seeking to depose the sitting prosecutor on that criminal case? Is that what you're telling me, Mr. Fusco?
No, sir. There are cases where that has been permitted. It's been different situations, different circumstances. They're factually different than this one. I can certainly pull some for the court. I just, to be honest, didn't think it would be necessary based on just the rules of discovery in the video in and of itself, but I will provide some, Your Honor.
Okay, well, I'll certainly give you an opportunity to do that because I will tell you that the court disagrees with your interpretation of the rules of criminal procedure. As I've already indicated on at least one issue here this morning. But in any event, I'll certainly give you the opportunity to supplement your request to the court with case law and the same for the state, because I didn't see anything cited by the state either. I know that you had cited a case dealing with the generic discovery responses, but that's not really applicable here today. So if both sides wish to avail themselves of the opportunity that the court is giving them to supply case law to the court, I'll certainly do that. How much time do you think you would need to do that?
I'll get it to the court this week. I'm in a wrongful death trial starting next week, so I'll get on that today as soon as possible.
Okay, Ms. Owens.
That sounds reasonable, Your Honor.
So when do y'all want to come back?
Any date works for the state.
Whatever's best for the court.
Well, you said when are you starting your trial?
Jury selection's on Monday, Your Honor, and it goes till the 19th, 11th through the 19th.
And that just the jury selection or the trial?
Maybe a pick and go. We still have so many issues to iron out, Judge Dees and scheduling. We'll find out, I think, a lot more this afternoon.
Okay. Madam Clerk, can you move your paper there? Because I'm looking at August here. Sorry. You want to come back the week of August 1st? You think you'd be done by then?
Yes, sir, that's perfect. I believe we do have court on this case on August 1st. So that's,
Oh, do we?
yes, sir.
Where's my sheet here? Okay, well, let's do that then. Let's come back August 1st and I'll give when did you say you'd have the case law by the end of the week? Because I'd like to come back on the 1st for ruling on the motion is what I prefer to do.
Yes, sir. Ideally, honestly, I'll try to get it to the court today or tomorrow, as soon as possible. I've done a lot of research on the issue, so.
Okay, well then I'll give the parties to the end of the week to, actually, I'm going to give you to the end of next week. There's no big hurry on it since we're not coming back to the first. So any additional materials will be supplied to the court no later than July the 14th. And then we'll come back August 1st for ruling on the motion and then hearing on the motion to be set that week on any additional matters. I know there's some other pending, which as you said, may flow from the courts, whatever the court's ruling is on this one. And Mr. Fusco, I note that speedy trial is scheduled to run September 27th. Doesn't matter to the court what you do with that, but have a discussion with your client, and depending on what you decide to do on that issue, will determine whether or not the court sets the case for trial relatively quickly on that August 1st date.
Yes, sir.
Anything else from the state?
No, sir.
Defense?
The only thing remaining, Your Honor, is the statement of particulars. We filed that motion back in May. The state had mentioned they were going to respond, and we still have yet to receive a response.
State?
Yes, sir.
When are you going to respond? Huh?
I will respond.
When?
When? Respond today. Your Honor.
Okay, she's going to respond today, allegedly. All right. No, try to get it done by today or the end of the week. Okay, anything else?
Nothing from the defense, Your Honor.
All right, thank you both,
Thank you.
and we'll see you on August 1st. Court will be in recess until, is it 1:30 or 2? We have our sensing 1:30? All right, 1:30. No, you need to appear in person as your punishment for not telling your colleague yesterday. No, Zoom is fine. Are you all right? Were you sick?
Yes, sir. I just had a too much fun.
She made it a point. She wasn't, I didn't even know she knew it was you necessarily, but she made it a point to tell us she didn't know she was supposed to be here until 9:10 is when she got told. But that couldn't be because she was here like right after that. In any event, I'm glad you're back on your feet.
Yes, sir.
And Zoom is fine.